All right, I believe we are ready to begin. Good morning, everyone. Welcome to the September docket of the Kansas Court of Appeals. I'm Judge Thomas E. Malone. We also have Judge Michael Boozer and Judge Anthony Powell on this panel. We're hearing this case this morning by Zoom under our special COVID-19 rules that allow us to do that. I want to thank the attorneys for participating in the hearing in this method. I'll repeat the preliminary remarks that I made earlier. I do remind the counsel that we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument this morning. As the presiding judge, I'll be the timekeeper. Each party is given 15 minutes for your argument. The appellant's attorney should let us know at the beginning whether you wish to reserve any of your time for rebuttal. After the hearing is completed, your case will be deemed submitted for decision. After that, we'll take the case under advisement and get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll go ahead and call the next case on the docket. It is from Johnson County. It is number 121754, entitled The State of Kansas versus the Estate of Nicholas Sands and R.M., a minor child by and through his mother. This case is a paternity action in which the estate of Nicholas Sands is trying to set aside a judgment of paternity entered in district court. And so we'll begin with who do we have for the appellant this morning?
Good morning, Chris Wilson on behalf of the appellant. My client, Kara Sands, the mother of the deceased, appears as well.
And for the appellee?
Your Honors, I'm Robert McRory for the appellant.
All right, and Mr. Wilson, do you wish to reserve any of your time for rebuttal?
Yes, if I could reserve 3 minutes, that would be appreciated.
That is granted, and you can begin whenever you're ready.
All right, thank you very much. I appreciate being able to appear. Initially, this is a case that is very unique. I've practiced 28 years or so, have not seen anything like this, and my practice is domestic work, and you all see this stuff all the time as well. This is very unique to what I have seen. Thus, I think starting off, I think that the appropriate view on this, at least from our perspective, is a term that was used in a case that I cited called scales of justice. And here, there is no doubt that Mr. McRory has good arguments and that all of us as attorneys respect finality of judgments, and we respect court decisions that provide parameters to statutes. Our system wouldn't really work without all of that. But here what we have is a very human element that is butting up against this principle of finality. And this very human element is a little boy, and families that are aligned with this little boy in different manners. And quite frankly, right now, what we have with the order is a very good indication that this current order is just simply not true, that it is a fiction. And the issues here, I think, are very straightforward. This little boy has a right to know his paternity and have an opportunity to do that. And what we have to begin here, and I think is really important, is that the mother in this case submitted a stipulation and signed it and agreed that she wanted the paternity order set aside. Within her stipulation, she agreed that this individual, Nicholas Sands, who's now deceased, is not the father. She agreed that there was a prior paternity test that said he was not the dad, and agreed that it was in the best interest of the child to set aside the order.
She took all that back though, right?
Well, she did, but it is evidence. But also what I think is important, and I agree with you there. I agree. What I would state, though, is that the court, in making its ruling, made specific findings with respect to what it felt regarding the mom's testimony. One of the things that the mom stated in her testimony was that she did not know the father's identity. So Judge O'Grady, and was faced with a very tough case, found her testimony to be reliable and credible, more so than what was the initial stipulation. But in that testimony, she said that she did not know the father's identity. I think that is critical here, because if she doesn't know the father's identity, we have an order that says that Nicholas Sands is the dad. And with that, she's saying and is testified in her testimony that the judge felt was reliable and credible. The question was asked of her, do you believe it's in the best interest of the child to have an order in place stating Nicholas Sands to be his father? And she said, no, I don't. And so that's what she testified to. And that's in part what the judge found to be credible and reliable. I think here as well, we have, as I mentioned, we have this prior paternity test, which I agree with Mr. McRory. It's much like the one he attached to one of his filings in this case for another possible father. It was one of those send it off type tests. But right now we have a case in Johnson County District Court 20 CV 1902, where we have preserved Nicholas Sands' DNA through a court order. And so we are positioned to be able to conduct a paternity test. What I would say, though, here is very importantly, is that the truth matters. And, when I look at the statute provides in subsection B6, this all-encompassing any other reason that justifies relief language. We know that that's constrained by case law. But what we have here is almost a perfect storm of what potentially this statute was meant to cover, which is extenuating and unique circumstances. That's to give the court the opportunity to correct wrongs or to try to fix a situation that has lifelong implications. Right now, I think this little boy is 10 years old, and there's a court order that says that Nicholas Sands is his father. So what that does is it throws this young man for the rest of his life into a bit of chaos regarding, all right, we have a court order, we have a family on both sides that is dealing with this.
Mr. Wilson?
Yes, sir.
With regard to 6260B6, do you agree with me that in addition to the requirement that you had to establish in order to set aside the default judgment, that request was made within a reasonable time?
Yes.
And do you agree with me that the district court found that your motion was not filed within a reasonable time?
I agree that was the finding, yes.
All right. My question then is, why didn't you appeal that adverse finding by the judge?
As far as the determination that it was not within a reasonable time?
Correct.
Well, Judge, and I would say this, it's because I think the whole 60B6 argument overlaps that. And I think that with respect to what the judge referred to and the findings made by the judge, I think this all goes back, in my humble opinion, to the language of 60B6 in the sense of its breadth. And I think when we're here in front of the court, I do understand that this motion was not filed by the estate until roughly 3 years after the last court appearance, or a little bit more. There is no escaping that, and there's no escaping what the lay of the land is here. The question, I think, becomes, with respect to that time frame, is based on the kind of the scales of justice in trying to determine what the best route is from the perspective of a finding. Which way do the scales of justice tip? And so that's been my focus. And my focus is because I think that the statute overlays all of those issues. The Vogler case refers to substantial justice under all circumstances. And that's a case that was cited by the Fisher case, that unpublished opinion. And what is right and just under the circumstances is being a contrary mission to the finality of judgments in these timeframes that are being applied. And so, here, what is a reasonable time frame? It's very difficult because this young man died in August of 17, and the first opportunity for the estate to really deal with this was subsequent to that and after the appointment of the estate. And so,
Mr. Wilson, can I interrupt you for a moment? Because I think I understand your position, but I want to ask, since you've sort of raised the issue, what sort of triggered the estate's action here? I mean, the estate, technically speaking, doesn't have any liability to this boy with the death of the father. Is this being prompted by a potential wrongful death action being pursued by the state and a potential recovery from that, and then a concern about, who gets the proceeds from that? Should any proceeds be collected? Is that the concern that the estate has? Is that we've got another heir here that we have to deal with? Is that the reason for bringing this?
What I can tell you is that I was approached by the mother of the deceased on behalf of the estate, and there was a twofold issue. Number one, from her perspective, as referenced in my initial filing in this case, was the concern that this child would be still looking to their side of the family as being the father, basically the paternal side, and the confusion and all of the issues that were raised there. Clearly, and my client gets in tears regularly over these issues, particularly with having a deceased son and what transpired. But part of it is, and you'll see in the transcript, there's a reference by Judge O'Grady where my client and the mom went out in the hall and they came back in, and Judge O'Grady checked with Ms. Dorsey to see if she was okay because she was crying. And she said it was just a reunion, and they were close. And so that's part of it. I'm absolutely, and I put this in my initial pleading, there is the wrongful death action. And so that certainly was a component that helped trigger this. So it was twofold, and there was no doubt about that. And that has been part of what the discussion has been.
Mr. Wilson, I'm on you as to the other point that you were making. How do we get around the requirement of reasonableness when you haven't challenged it? It seems to me it doesn't matter what portion of 6260B you're trying to set aside a judgment, except maybe the jurisdiction provision, but the ones that are applicable here, and certainly the one that you've raised, you use to justify setting aside the default, isn't a reasonable period of time to bring that motion the standard for virtually all of those. And if you haven't challenged that, how do we get around that?
Well, I do believe within my brief, my reference to this issue is really the idea that I don't think that the matter of whether it's 2 years, 7 years is the overwhelming factor here. I think the overwhelming factor here is the reasonableness versus the issue that we're dealing with, the gravity of what we're dealing with. We're not dealing with whether and we all know this, but we're not dealing with, whether someone has to pay, $80,000 because they didn't come back on a default. We're dealing with this kid's life and these families' lives. And so I think that the gravity of this outweighs what these timeframes are. Again, I think that if this were 2 years, 3 years, 7 years, we'd be still grappling potentially with the same issues. And I think that when we start talking about, what is reasonable here, when we are faced with what we're faced with in the case law, I think that answers that question, meaning. Yes.
Mr. Wilson, let me get then to the sort of the next nugget. Let's assume for the sake of argument that the district court got it wrong, that you did bring it within a reasonable period of time. And then we're getting to the merits of your argument. Mm-hmm. Don't you still have to show under In re Marriage of Ross that it's in the child's best interest. And isn't that a problem in this case when what you have is that if we don't set aside the paternity finding, we have a child who we at least legally knows who his father is, and then has the potential to obtain money or a recovery from a wrongful death suit. But if we go the other way, as I understand the record, we don't really know who the father is. So we're in essence making the child fatherless, and he loses out on any potential recovery in this state. How is that in the child's best interest?
Well, from the appellant's standpoint, we're not asking you essentially to make that call. I think that all that would happen is that you would remand it to the district court, and there are many results that could occur from that. That is, I think we'd have to have a Ross hearing. I think what the court would do is appoint a guardian ad litem to represent the interests of the child. That guardian ad litem would then weigh in on the propriety then of challenging and moving forward on the paternity judgment. That guardian ad litem, quite frankly, could come back and say, look, my recommendation is this, and the judge would have to then have a hearing as to whether we would do the paternity test. And so that's my understanding of Ross, is that once all we're asking is that the decision that not to apply 6260B6 to this circumstance be reversed and remanded and say this is an applicable situation for that because of the gravity of what we're dealing with. And then it goes back to the district court's lap, I think.
But aren't you going to have to make those arguments? I mean, you're going to have to make some argument to the court, or otherwise, what's the point, right?
I agree with you, and I think that we'll be able to present that, because I think that when we get a paternity test, if the judge allows, well, that's working a little backwards, but with the guardian ad litem coming in, that guardian ad litem and then the court's going to have to assess at that point in time with the full presentation of evidence. And again, we were foreclosed from that a bit, where the court did not permit us to present additional evidence where we thought we were going to get to do that. And we feel that if we were able to present family members, really have a full bit of testimony from mom and family members as well, that would provide additional insight. The transcript that we have with respect to Ms. Dorsey was with respect to that initial motion hearing. And we were going to have further proceedings, but that was not permitted.
Thank you, counsel.
All right, thank you. You know, I think
Wilson, you're going into your rebuttal time, so if you want to still reserve 3 minutes for rebuttal, you'll need to wrap this up.
Okay, I'll conclude at the moment and reserve the rest for rebuttal. Thank you.
All right, Mr. McCrory.
Thank you, Your Honors. I'm going to like to initially respond to some of the remarks made by counsel for the appellant. Frankly, I couldn't disagree more. The remark about this case being unique, I don't see anything that's unique about this. This is a paternity case, perhaps the most common type of case, or one of the most common types. This was a default judgment entered in a paternity case. Happens all the time. Nothing unique about that at all. Then we have a home paternity test. Nothing unique about that. Those things undoubtedly are they're available through all sorts of retail stores, and they're pretty much useless. They are notoriously unreliable. Then the next thing that happens is that a man dies. Absolutely nothing unique about that. That's going to happen to all of us. Now, Mr. Wilson talks about the stipulation and how important that is, that makes this case somehow unique. But that stipulation was withdrawn. It doesn't exist. The case, frankly, that the appellant really relies on, Fisher versus Davis, likewise had a stipulation that was withdrawn. Once it's withdrawn, it doesn't matter anymore. The court found that my client's remarks about the paternity of her son, that the remarks that she made saying that Mr. Sands was the child's father, was more credible than anything else. So that stipulation is simply gone. So there's nothing unique about this at all. Paternity case, default, death. I don't see this as being unique in the slightest. Now, the question was asked, what's really this case all about? And in all candor, it's real simple. It's about money. This suggestion that the estate cares about Ryland Mills, utter nonsense. Nicholas Sands had nothing to do with the child. Nicholas Sands' mother, Kara Sands, had nothing to do with the child. The suggestion that they care about this child when there's been no contact whatsoever, absolutely ridiculous. It's about money. That's what caused this case to get going, was the wrongful death action and $100,000 insurance policy. Now, Ryland Mills is actually 9 years old now.
Actually, please, you should use initials.
Oh, I'm sorry. I'll just say the child, if that'd be all right. The child is now 9. Now, there's a statement that Nicholas Sands was in custody at the time that judgment of paternity was granted. That's not correct. The court records show that he had been released from custody about a month and a half before that hearing. Furthermore, he appeared at a subsequent hearing and indicated that he was going to seek to set aside the judgment. He never did that. He passed away 2.5 years later. The estate filed its motion to set aside the judgment 3.5 years later. It's also important to emphasize that the other potential father was a man named Travis Mills, and he was excluded by a proper DNA test in the paternity case. And Ms. Dorsey indicated that there were only 2 potential fathers, Nicholas Sands and Travis Mills. And again, Mr. Mills was excluded by a proper DNA test. Now we have that DNA test, or that home paternity test, as I like to call it. It's clearly not reliable. Pages 27 and 28 of my brief, I set forth 9 reasons why it's not reliable. And in any event, that home paternity test was performed years before the paternity case was even filed. So it can't possibly be considered newly discovered evidence, as Mr. Sands had those results years before this case even started. But even if somehow that's not correct, the fact remains that that would be newly discovered evidence which would have come into existence, and the motion to set aside judgment based upon newly discovered evidence has a 1-year time limit. And it's been well past 1 year since the judgment was entered before the motion was filed. Again, as Your Honors noted, the district court found that there was inexcusable neglect or willful failure to act. The court noted that 30 months passed between the time of Mr. Sands' court appearance and the motion being filed. I'm sorry, 30 months between the time of his court appearance and his passing, and then 41 months between the time he announced his decision to try to reopen the judgment until the motion was actually filed. And the court found that to be not a reasonable time period.
Counsel, am I correct from the record that from the time of the status conference when Nicholas appeared in person until his death, he made some payments on child support to about $486?
Yes, sir.
Thank you.
And that obviously ties into the second argument of acquiescence. His monthly child support obligation was $421 a month. Now, it is true that child support payment was per a wage garnishment, but I cited 2 cases, Younger v. Mitchell and Vatt v. Diamond, both of which hold that allowing a garnishment to take place can be an indication of acquiescence. And I would further contend that when you have a situation where the deceased never acts to seek to set aside the judgment and he allows his wages to be garnished, that is clearly an indication of acquiescence. And with acquiescence, that terminates or prevents the movement from being able to pursue this motion. Since the estate only takes over what rights that the decedent has, the estate likewise is barred by acquiescence. I have further set forth a number of cases, and again, I don't know how, in a sense, relevant it is, given that the estate seemingly concedes that it did not act within a reasonable time period. But I would note that 6260C specifically states that a motion under subsection B must be made within a reasonable time. That's a direct quote of that statute. There's the Bowers decision of 1997, which held that 4 years was too long. Boldridge, which said 46 months. We've got the Rawlings-Roa versus City Loft decision of 2015, which held that 29 months was too long. And that decision cited Nagel, which held that 2 years was too long, and McLeish that held 20 months is too long, and Brad Investments, which held that 2 years is too long. Robinson versus Spencer, which held that 1 year is too long. Additionally, I cited the Larson decision. 9 months was too long, and in Larson, the movement actually took some actions to try to resolve the matter after judgment was entered. And yet 9 months was too long to seek relief under 6260 B6. So what I've heard from the appellant is this generalized remark of the gravity of this matter. This case is so important. Let's just forget about a dozen or more decisions. Your Honors, I don't think one can do that, okay? I don't think that simply saying that we think that this boy should have a different idea about his father or his father's identity, both of which are deceased, or all that can outweigh the law. Furthermore, there isn't any reason to believe that Nicholas Sands wasn't the child's father. The other potential father was excluded by a proper DNA test. Nicholas Sands chose not to show up for his DNA test. He chose not to even challenge this. I don't see any reason whatsoever to believe that Nicholas Sands isn't the child's father. Now, I guess one can take multiple steps backwards and say, well, then why did Lauren Dorsey sign her document? Why did she initially sign the stipulation? Well, we've got plenty of hints about that. The man that had been acting as the child's father had been murdered recently. She's upset, she's crying, she's distraught. She didn't want to have anything to do with this matter. And so she said, oh, he's not the father. And then she says, oh, I'm not sure if he's the father or not. And then, of course, calms down and says, well, of course he was. Okay. And that's where the case is. And I don't think it's any more complicated than that. Now, another questioning of the appellant's counsel that I heard was, in effect, a remark about the child's best interest. Well, the district court did address that. That's in the decision, that the district court looked at that. But you've still got to even get to whether the motion to set aside judgment, whether there's excusable neglect. The district court cited a federal case, Lorenzo, it's a 2002 case. And I quote just a portion of that, quote, at bare minimum, a party who seeks relief from judgment on the basis of excusable neglect must offer a convincing explanation as to why the neglect was excusable. And again, the estate has offered no explanation as to why the neglect was excusable. The estate has cited basically two cases. There's the Wirt decision, it's a tax case. And in that case, basically there was a clerical error And that clerical error affected a tax calculation. And the appellate court, recognizing that there's no dispute in that case, just simply acted to correct that error. It's hard for me to imagine a case much further away than this one, where in this particular situation, obviously, that's not even remotely close to a paternity action. And there is no agreement as to some change that should be made in this case, unlike in the Wirt decision. Then the other case that's cited and was just mentioned by appellate's counsel is the Vogler decision, which is a medical malpractice case. And in that case, the district court basically gave a directive to the plaintiff, telling the plaintiff to dismiss and refile in order to correct a procedural error. And the plaintiff followed that instruction, but in doing so, that created a statute of limitations problem. So in short, following the district court's directive adversely affected the plaintiff, and that's a situation then where relief was granted to the appellate court, or relief was granted by the appellate court. Again, very, very far away from the facts in this particular case.
You have about 1 minute.
Okay. I would note, though, that the other case, Fisher versus Davis, that's been cited repeatedly, actually helps my client. In that case, that's the one where there were inconsistent home paternity tests, which show again how unreliable they are. And also in that case, an affidavit was withdrawn, just as in this particular case, with no consequence to the writer of the initial affidavit. Final argument that I would make is with respect to standing. I cited the Fincher case, a 2018 decision, which notes that the probate code treats a determination of parentage pursuant to the Kansas Parentage Act as conclusive. That's a quote from Finchler. Therefore, the estate lacks standing to contend that the child is not the son of Nicholas Sands. Again, quoting Finchler, quote, "Only a child or person acting on behalf of a child may bring a parentage action. Accordingly, the estate does not have a legal basis to bring a parentage action, yet in this case, the estate is seeking the reversal of a parentage determination. KSA 59-1401 sets forth the permitted actions that an administrator of a probate estate can take, and the statute does not indicate that an estate administrator may seek to set aside a judgment of paternity. In short, a paternity finding is binding on the probate court, and an administrator may not seek to set aside a paternity finding. Therefore, the estate lacks standing to pursue the motion and appeal. Accordingly,
Mr. McCrory, if I could ask real quick, did Judge O'Grady make any findings with regard to that issue, whether or not there was standing for the estate to make this claim?
Yes. Judge O'Grady determined that the estate did have standing.
All right. Thank you.
Okay. Thank you. Appreciate your consideration.
All right, thank you, counsel. Mr. Wilson, you still have your 3 minutes of rebuttal. You need to unmute.
I am unmuted. Thank you. You know, I hear Mr. McCrory, and I've heard the arguments in court, and really, you know, in the proceeding we've been engaged in, and really what this is, and it's unfortunate, it's just this avoidance of determining the truth. A simple paternity test will give us the truth, and that's what we're here, and that's what this fight is. And when Mr. McCrory says, well, there's only 2 possible fathers, I would suggest otherwise. I would suggest there's a universe of potential fathers, and you know, we're talking about a couple people that she's identified. What I also think is interesting is Mr. McCrory refers to the Fisher case and then states that in states 2 cases cited, Wirt and Vogler, are irrelevant because they're related to different facts and circumstances. But the Fisher versus Davis court in the unpublished decision, and two of your honors were on that panel, cited Vogler for in a paternity action for the principle of substantial justice under all circumstances. And then also the direct quote, give due regard to the sound interest underlying the finality of judgments, the district court nevertheless has the power to grant relief from a judgment whenever, under all the circumstances, such action is appropriate in the furtherance of justice. And that's what our argument is in our brief, is that under all the circumstances, why is there such this fight to avoid the truth? I understand the characterization that this isn't claimed to be about the child, but remember, it's Ms. Dorsey who was acting without an attorney, signed a stipulation before court, not when she was in tears. She signed it before court, came in with the intention to just bring this to a conclusion, and then when shuffled to an attorney, then changed her mind because of the potential of this lawsuit. That also has a double edge to the sword. But the fact is, regardless of what we want to say about whether it's about the child or not, the fact is that the law under Ross states very clearly that the Court of Appeals correctly construed the Parentage Act to provide that every child has an interest not only in obtaining support, but also in inheritance rights, family bonds, and accurate identification of his parentage. That to me is the overlying principle in this entire matter. Are we going to seek the truth, or are we going to let finality of judgment stand in the way? And from our perspective, the truth for this child and for all the families is substantial justice, and the balance here tips in that favor. Thank you.
All right, counsel, thank you very much for your briefs and your arguments. I don't know if this is a unique case or not, but it's certainly an important case for the people involved. And so we will get a written decision out to you and your clients just as soon as we possibly can. And so with that, court is adjourned for the morning.